So the SEC ended up suing us in December of 2020 because we wouldn't come in and register because there was no way to register without killing the business. And we spent the next 4 years fighting the SEC. We invested $150 million in defense costs, and we won.
I don't want to spend too much more time bemoaning the past. It happened. More is going to come out, but that's not our purpose. What Gary Gensler did was gave cover to traditional finance firms not to modernize.
So while we were fighting the SEC in the U.S., what we did was, after we had a brief conversation as to whether or not we needed to shutter the company and just distribute whatever assets we had to the shareholders, and it was a very real conversation that we had in January of 2021, we said, you know what, let's go outside the U.S. and let's continue to build our company. And that's what we did for the 4 years that we were fighting the SEC. We built our company up in Singapore, in London, in Dubai, in Brazil, in Europe. When the SEC sued us, we had 400 employees. Sitting here today, we have 900. Most all of those were hired outside of the U.S. We're now, 96% of our customers were signed outside of the U.S. So the opportunity now to make the U.S. the crypto capital of the world is to bring those jobs, bring those tax dollars, bring those opportunities back onshore.
We should never again allow a political response to innovation to stop innovation. Innovation is the lifeblood. It's what we do best in this country. And in some ways, we've lost our manufacturing base. It's all we do best. And we need to play to our advantages, which is we need to be on the cutting edge of innovation. And we can't let political reasons stop us from doing that in the way that has just happened. So you have to view what the SEC did in the last 2 years as really designed to be disruptive.
In this video, former CFTC Chairman Giancarlo and Ripple's Chief Legal Officer Stu Alderoty celebrate recent developments regarding the SEC versus Ripple case at Wharton's Demo Day. The two blockchain vanguards share insights gained on their colorful journeys, energized by real-world events that shocked the industry. The panel was moderated by Jessica Reiner, Managing Director of Digital Finance at the Institute of International Finance. Stu shares Ripple's personal struggles stemming from its lawsuit against the U.S. SEC for the past 5 years. I did get to ask Stu what he's going to be doing with his free time now that Ripple's lawsuit is over with the SEC. He said he's going to shift his time and energy on the National Cryptocurrency Association, where he sits as the acting president of the forward-thinking nonprofit, which aims to showcase blockchain's real-world impact across America and exploring how digital assets are empowering everyday people and businesses today. Chris talks about the importance of learning from our mistakes and instituting sound regulations, paving a clear path for innovation. Stablecoins were also a major focus of the conversation too, so this is a discussion that you don't want to miss. And thank you for your patience with the audio. External sounds from the event got the best of my noise-canceling Rode lapel mics. Regardless, this is a world-class conference, and I'm incredibly grateful to be in attendance. Thanks for tuning in. Love you mucho.
We've got Stu Alderoty, who I like this. Stood up to the SEC, and he's still standing. Right? I'm sure we'll hear more of that story. And Chris Giancarlo, who's at CFTC, previous administration, 2 administrations ago, and of course was central to the progress of crypto towards where it is now, right? And the progress that can be made at the CFTC. And we've got Jessica Reiner moderating it. So we're going to do it sort of fireside chat style. I guess people should just throw in questions when they got them, I guess. I will. So please, and then welcome our distinguished guests, and this should be a lot of fun.
Perfect. Well, excited to be here. I'm with two awesome people to talk to us today about this topic. I would also really like to hear about crypto beyond the turbulence. So I'm going to have a good discussion. I think one of the things that's really, important to think about as today, we have so much happening. We have numerous executive orders. We have Congress looking at potential legislation. We now have forward momentum in an area where we have just been stuck for quite a while. But I think to understand that and to have a discussion around that, it's really important to understand first kind of what, where did we come from? Kind of what occurred over the last 4 to 5 years that now has brought us to this point so that we can then understand what to do about it. So with that, I'm very lucky that I have both an industry view and a regulator view on both sides. So I'm going to start actually with you from the industry view to kind of walk through a little bit of how did you see the last 4 to 5 years to get to this point?
Sure. So Ripple was founded in 2012, American-born company, entrepreneurs who look to build out crypto and blockchain. Our customers are institutions, payment providers, and we want to move money around the world faster and cheaper, more transparently than traditional rails. So that's just the background. And we were doing that for a good 8 or so years. And then all of a sudden at the Securities and Exchange Commission, there started to grow a political hostility around crypto in the U.S. Initially focused on what we call ICOs, and we could have a discussion as to whether that focus was appropriate or inappropriate. But then it expanded to all crypto companies. And Ripple was the first target of the SEC, what I will say in a non-ICO context, a really developed company that had developed a business based in the U.S., investing people in the U.S. We had real shareholders. And all of a sudden the SEC said, to continue to operate in the U.S., you need to come in and register your use of a cryptocurrency with the Securities and Exchange Commission. And we had conversations with them that went on for 2 years. I come from traditional banking. I served as general counsel for some of the largest banks in the country. I've dealt with regulators before. I think we had a conversation and come to a sensible resolution. But there was no resolution to be had because this concept of come in and register the crypto that you're using, there was no facility or mechanism to register. The laws and rules had not yet been written. So the enforcement was coming in front of laws, rules, and regulation. We call that regulation by enforcement. So the SEC ended up suing us in December of 2020 because we wouldn't come in and register because there was no way to register without killing the business. And we spent the next 4 years fighting the SEC. We invested $150 million in defense costs. And we won. We won on a really important issue that the digital asset itself is never the security. And that's something that Chris had the foresight to see even before he was sued, and he published a scholarly article on that point. So we went on, the crypto itself is never the security. The secondary market trading, where there's blind bid-ask trades, and you don't know who you're buying it from, and you don't know who you're selling it from, that's not a security transaction. And the use of your crypto for other purposes like philanthropy, grants, payment compensation, not securities transaction. But after we were sued, all of the other major players in the U.S. started to get sued, like Coinbase, etc. All of these suits were misguided, and I think until now, we'll talk about the pivot where we are now, we're headed for a series of losses for the SEC. And I'll just add this. So this is not just a litigant who's angry, railing against the SEC. The court in our case at the SEC was not faithfully applying the law. In 2 other cases, the courts found that the SEC was acting arbitrarily and capriciously. And in a 4th case, the SEC was actually sanctioned by another judge for outright misrepresenting the facts of the crypto case to the judge. So something was really amiss.
So good start. We're going to come back to the actual cases themselves and perhaps why they're being dropped now. But I'm going to switch over to Chris. From your standpoint, then, from a regulator who was acting at that time, how do you see the last 4 to 5 years?
Well, actually, to give a perspective, I'm going to go back a little bit further, maybe the last 40 years, if you don't mind. The dominant economic philosophy of the United States and really most of the Western democracies, going back from the 1970s and 80s to the end of the 20th century, was influenced by economists like Milton Friedman and politicians like Ronald Reagan and Margaret Thatcher. That the basic philosophy was, albeit imperfect, the marketplace is the best way to allocate capital amongst members of society. And that was pretty much the dominant philosophy until the early 2000s, and then accelerated by the great financial crisis in 2008. An alternative philosophy came about and became quite prominent, and that is to say that, in fact, the market has done a terrible job of allocating capital to a series of underserved communities. And to address that imbalance, we need a political component in allocation decisions of capital. We need more of a political control over Wall Street. And things like Occupy Wall Street and others are reflective of the notion that there needs to be greater political control. Now, these two philosophies really didn't easily divide between Republicans and Democrats. If anything, there was also a generational element in this as crypto came on the scene. But what crypto did was to challenge both the market philosophy and the political component to say, you know what, if we get the algorithm right, we can actually do a better job of allocating capital however we wish to do it. It's all about the algorithm. We don't need politicians, and perhaps we don't need an unfiltered free market. So crypto really was quite challenging to these dominant philosophies. When I took up my baton at the CFTC in 2014, I discerned amongst political players in Washington real differences of opinion on what crypto was and what it meant that were more, I'd say, all over the place. And that continued during the first Trump administration, Trump 45, during my tenure as chairman of the CFTC. We were able to launch Bitcoin futures, really not just the United States' first fully regulated market for crypto, but the world's first fully regulated market for any type of crypto product, in that case, digital commodity derivatives, without a lot of overt hostility. Crypto really became political, I think, during the Biden administration. At first, there was a growing divide between what I would say Democrats like Elizabeth Warren, who didn't reflect all of her party, but certainly reflected that view that said, we want to keep political control on this. And we've worked hard to get political control. And we're certainly not going to give it up to a bunch of 20-year-olds in cargo shorts and hoodies that are crypto bros. And more free market types continue to hold, this is a new innovation that we should pursue. But it really became political after Sam Bankman-Fried. That's where it became a R versus D thing. Sam Bankman-Fried really embarrassed the political class. More on the left, because that's where his overt money was going, even though there was a lot going to the right side of the aisle as well. That was more covert. And so therefore the philosophy became the best defense against our hypocrisy on this will be a good offense. Let's attack it. And that was really leadership like Elizabeth Warren and others. And Gary Gensler became their tool to do it. And what I saw quite clearly over the last 2 years of the Biden administration was a wholesale effort to destroy crypto in its tracks. And some of the techniques used were outrageous. I mean, we talk about presidencies that go outside norms. The norms that the CFTC broke in the last 2 years are really quite shocking, to the point where a federal court found the SEC to have lied to the court and sanctioned them for doing that. I mean, that is, I had one of my staffers look back. We couldn't find that it ever happened ever in the history of the SEC. Now, maybe it happened back in 50 years ago, but that's how bad things had gotten in terms of hostility. And in fact, that hostility turned out to be a total detriment to the party in the last election. So they had gone outside the norms, and the pendulum forced things back. And now we're in a different era. And I'll just end on this note. The turbulence hasn't ended. The hostility has ended. But now we're in a vortex. We have an administration that's moving at startup speed in terms of implementing executive orders, moving forward on legislation. I fully expect we'll have stablecoin legislation on the president's desk and signed by the August recess. And I think there's a very good chance we'll have crypto legislation by the end of the year or early next year, certainly by the midterms. And there's a lot going on there. The stablecoin legislation certainly needs a lot of attention. The crypto legislation does. So there's a lot of moving pieces going on right now. And we'll talk more about that. But we've been through a lot in the political realm over the last decade or so.
We're definitely going to come back to the legislation and dig into that a little bit. So coming back to, as I promised, some of the cases and some of these completely out of the norm behaviors for an agency. Now that there are so many different things being dropped, why do you think they're being dropped, other than them just having been out of the norm and inappropriate? Why do you think they're being dropped? And kind of, I don't know, how do you see that falling apart
Sure,
right now?
sure. So, I know it doesn't look it, but I've been practicing law for 40 years, and I agree with Chris. And I've dealt with, again, major financial institutions, major regulatory issues, every major regulatory body and law enforcement authority in the United States. I've never seen one behave the way the SEC did under the prior administration. So when I'm asked, why is the SEC now walking away from all of their crypto enforcement cases, I'll answer it. But I think the real question is, why were they brought in the first place?
Exactly.
And I think the reason they're being dropped now, and if you look at the statements from Mark Ueda, the acting chair, Hester Peirce, who set up the crypto task force, and other statements that are coming from policymakers, they understand that you have to first build the laws and the rules and the regulation before you can bring any enforcement action for violating those laws, rules, and regulations. And really put the cart before the horse when it came to enforcement action, and that is not the way you should do it. So why are we tying up these companies in endless litigation that is headed to an adverse decision for the SEC, taking their staff, very talented staff, let's pull them off of these enforcement cases and let's work on regulation. And for the SEC, I think the question is, what is within their jurisdictional boundaries? Because that's what these cases are all about. It's not about whether consumers deserve protection. They do. It's not whether markets need to operate or they do. It's not whether we need to keep bad actors out of the crypto space. We do. The question is, who has the jurisdiction to do that? And if it's not the SEC, and in most cases it's not going to be the SEC, it doesn't mean that there are other regulatory bodies that won't step into the breach. And if there's a breach that needs to be solved for by legislation, let's solve for it.
And there's another dimension. These cases were crafted and designed to be destructive, to destroy innovation. And this administration ran on a pledge to make the United States the crypto capital of the world, to be a positive. And so continuing these cases as they were crafted would be totally antithetical to the desire to have crypto innovation flourish. They had to be withdrawn because of their destructive nature. And you have to see those cases in the context of a whole series of other actions. One of the things that the SEC totally abused was what's called Wells notices. Under SEC jurisprudence, if they are going to bring an enforcement action against a firm, they first give a notice called a Wells notice that they're about to bring an enforcement action. It's supposed to be followed by a lawsuit. In many cases, the SEC was issuing Wells notices just to freeze firms in place, and then brought no action for a year or more. In fact, the firms had to go to them and say, put up or shut up. I mean, what do you got here? And we can't get funding. We can't go forward because we're under a Wells notice, and yet you don't have to have a case. And that was at least a dozen instances of that across the industry. So you have to view what the SEC did in the last 2 years as really designed to be disruptive. And this administration, if they're going to be in accord with their campaign pledges to let crypto flourish, has to withdraw this and then get on with the rule writing process and create a framework by which firms can then go on and succeed.
And what's the opportunity there now? So if we have an administration that's in place that is absolutely behind pushing innovation, allowing, making sure that we have clarity, figuring out a way to move forward in a sensible manner, then really what opportunity, especially for the role of the dollar as well, and then how does XRP play into that? Perhaps do you?
So We need to do two things. We need to do three things. The first thing we needed to do was to remove these hostile regulators, which happened very rapidly and plays to this president's, persona of requiring people, and that was done quite rapidly. So you take away those hostile actors, and you replace them with people that have not just give lip service to innovation, but actually have a track record of doing it. People like Hester Peirce and Brian Quintenz and Paul Atkins, the SEC, Brian Quintenz at the CFTC, but also at the OCC and elsewhere. Then we need to have rulemaking at the agencies. Even without legislation, we were able to show at the CFTC that we can use existing authorities to craft good frameworks for regulation. And when Congress gets around to embodying that law, even better. But in the meantime, much can be done. And now you're seeing a very active task force at the SEC looking at different frameworks that can be adopted, doing a whole series of roundtables and meetings with the industry. And it's, for people that have gone on to see the new task force, they come away amazed because they say they were actually listening to us and taking notes and asking good questions. Under Gensler, they were greeted with just stone faces and no reaction whatsoever, no indication of whether this would lead to anything. And then finally, we do need law from Congress so that these changes can be embodied and serve a long-term purpose. That's moving as well. As I mentioned, I think we'll see legislation. Certainly, the House Financial Services Committee, under its new chairman, French Hill, is moving forward with hearings and taking up legislation. The stablecoin bills have passed both committees of jurisdiction. They're just waiting for time. So things are moving very rapidly, and I think in those three areas: personnel, legal, regulatory frameworks, and legislation.
I certainly did hear over the last couple of years the cases where the SEC, various offices had become weaponized essentially for purposes that they were not established for in the beginning, and that individuals could get asked to come in and talk to them and to learn about what they were doing, and they would leave the door with an enforcement action. So glad that that's no longer the status quo. But perhaps if you think about where do we need to take this now that we have this opportunity, what do we need to be pushing forward?
Yeah. So one more anecdote. While all of this was happening above the line where everybody could see, what was happening below the line was Operation Checkpoint 2.0, that the crypto industry was being debanked. I was personally debanked. My CEO was personally debanked. Ripple couldn't get bank accounts in the U.S. And that story is now being uncovered because the regulators were told to debank. The regulators are telling the banks to unbank crypto because the risk was too high. So a lot was happening. So while we were fighting the SEC in the US, what we did was, after we had a brief conversation as to whether or not we needed to shutter the company and just distribute whatever assets we had to the shareholders, and it was a very real conversation that we had in January of 2021, we said, you know what, let's go outside the US and let's continue to build our company. And that's what we did for the 4 years that we were fighting the SEC. We built our company up in Singapore, in London, in Dubai, in Brazil, in Europe. When the SEC sued us, we had 400 employees. Sitting here today, we have 900. Most all of those were hired outside of the U.S. We're now, 96% of our customers were signed outside of the U.S. So the opportunity now to make the U.S. the crypto capital of the world is to bring those jobs, bring those tax dollars, bring those opportunities back onshore. That, I think, is the real commercial reason why we need to get this right. Secondly, and I agree with all of the points Chris said, secondly, what we need to do is we need to demystify and make crypto accessible for everyday Americans. We need to de-villainize it. And we'll talk about this in a bit. In addition to wearing my Ripple hat, I'm also the president of the National Cryptocurrency Association, a not-for-profit organization that wants to serve as the voice of everyday Americans who don't use crypto. We just released the largest ever crypto survey in partnership with the Harris Poll. We've confirmed that 55 million Americans, 1 in 5, own and use crypto. Let's stop villainizing them. And what we need to do is protect them. And the way you're going to protect them is through smart regulation and smart legislation, which is why we now need to take the most executive branch we've ever had and the most crypto Congress we have ever had, and get those laws free.
And just, I just want to add one other thing. I don't want to spend too much more time bemoaning the past. It happened. More is going to come out, but that's not our purpose. But I do want to say one thing. We lost a whole 4 years, and in innovation, 4 years is a lifetime. What Gary Gensler did was gave cover to traditional finance firms not to modernize. And now that cover's been ripped off, and all of them are rushing to get in. It brought a lot of people that could have gone into the space, kept them out. A lot of innovation that could have been developed. It forced a lot to take place overseas. It gave our economic competitors advantages against us. We should never again allow a political response to innovation to stop innovation. Innovation is the lifeblood. It's what we do best in this country. And in some ways, we've lost our manufacturing base. It's all we do best. And we need to play to our advantages, which is we need to be on the cutting edge of innovation. And we can't let political reasons stop us from doing that in the way that has just happened.
It also barred a lot of the more traditional financial institutions from not wanting or being able to modernize, even if they wanted to. You have capital regulations and capital requirements that are effectively punitive for the banks to even participate and work in this space.
Also the debanking. I mean, when again, the bloody mindedness of the administration, they went after Ripple's executives personally. They went after their, in law, they went after their bank accounts, and they were the poster child for it, but it was happening across the marketplace. I mean, it's truly outrageous what happened, and I hope there's accountability, but let's talk about the future. But what happened, it can never happen again.
That's right.
So
There's no accountability, though. It needs to be accountability. Not for retribution's sake, not for spitefulness' sake, but to understand how it happened, to make sure it doesn't happen again.
So to move forward, we now have this opportunity. So one of the risks certainly out there is from tribalism, from saying, okay, we all worked together to get this opportunity to push beyond the mountain and overcame all this stuff. And now we're all going to go back off into our own little corners and compete with each other in a way that doesn't turn into perhaps the best legislation or the best clarity. How do we avoid that as industry players?
A very, very important question. So in response to everything that we have talked about, the hostility, the war on crypto, the regulation, the enforcement, the lawfare, what the industry did said, you know what, we need to change the political landscape. So the industry came together. We built the largest ever super PAC created in this country, and we went out and we said we're going to support pro-innovation candidates, and it worked. What would now be a mistake of being so successful on that front is now we all go back into our corners and we retreat to this tribalism. What do I mean by tribalism? Bitcoin maximalists hate Ethereum. Ethereum maximalists hate XRP. XRP maximalists hate Solana. That is ridiculous. Bank of America, JP Morgan Chase, Wells, Citi, they all compete. Competition is great, but they're not all out there trying to destroy each other publicly. From those 55 million Americans who own and use crypto, they probably think of Bitcoin the way we use Kleenex, right? For tissue, right? Bitcoin means crypto. They don't understand all of these different protocols and projects. So the industry does need to come together. Ultimately, the policymakers will hold the hand on the policy. Ultimately, they will write the legislation. But the industry needs to work behind the scenes and strike that grand bargain of what do we need to make our innovation able to operate in the U.S. while we protect consumers, while we protect the integrity of the market, and while we keep bad actors out. And that's going to be a compromise. But that fighting, it's sort of like Thanksgiving dinner with the door closed with the family. That fighting needs to take place behind closed doors. And then once we go out into the hill, hopefully we're speaking consistently. Because we've spent all of this money supporting pro-innovation candidates, but they're going to spend a day having crypto companies and crypto trade organizations cycle through their door, and each one is asking for different things. They're going to say, what do you want me to do? What am I supposed to do?
To take that analogy even further, in the analog world, you had choice of deposit-taking institutions. this bank, that bank, this broker dealer, that broker dealer. You had choice of payment mechanisms, MasterCard, Visa, American Express, paper checks. You have choice of exchanges, NASDAQ, New York Stock Exchange. For some reason, in this emerging digital world, I identify a flawed thinking that seems to think that it's all going to reduce down to one layer one. It's all going to reduce down to one exchange. It's all going to reduce down to one payment mechanism, one stablecoin. It's not. People desire choice. There are going to be multiple stablecoins. There are going to be multiple crypto exchanges. There are going to be multiple payment mechanisms. There are going to be multiple layer ones. And what we've got to do is stop the infighting and start recognizing that. And an area that's a big focus for me is how do we modernize the US dollar? I'm head of something I co-founded called the Digital Dollar Project. And we asked three very important questions. How do we modernize the dollar? How do we preserve its reserve currency status? And how do we do so consistent with the values that the dollar has historically stood for, values of free enterprise, free economic expression? And yet, there seems to be a prevailing view that there will never be a sovereign digital dollar, or others that say there must be a sovereign digital dollar, or there'll only be one form of stablecoin. The fact of the matter is, everybody in this room, within 10 years, are going to be dealing with sovereign digital currencies, whether the U.S. becomes a digital dollar or not. They're going to be dealing with digital euros and digital yuan around the world. You're going to be dealing with multiple different stable coins. You're going to be dealing with multiple different exchanges and payment providers. And therefore, what we need to think about is, what are the core principles under which anything that represents the dollar, whether it's a tokenized deposit, whether it's a stable coin, or whether it's a sovereign instrument, if Bermuda's currency is based upon the dollar, if they launch a CBDC, it's a dollar-based CBDC. So we're going to be dealing with CBDCs in the future. We need to think about what are the principles. And what we advocate is that the United States, for the first time, accepted owns the dollar, trademark that instrument, and determine, just as if you want to license a Nike product, you've got 50 pages of standards. If you want to license the dollar for your stable coin, your deposits, there should be principles on which it's based, including personal privacy, interoperability, and other things. That's where we need to go when we think about the dollar. We've got a long way to go right now because we're still in there, digital dollar good, digital dollar bad. We need to get beyond that.
You know, one of the things I really like is the focus on principles. I feel like in this space, I too often hear the word novel applied to everything, like novel risks and different novel activities. And actually, from the risk standpoint, if you think about the risks, they're actually risks that are very well known in just the financial industry. Things like leverage, right? Things like cybersecurity issues, things like collateral. These are things that the financial system is very familiar with. But we just need to figure out how to then apply it in this setting, but not think of them as totally novel concepts. Which I think, I don't know, how do we
I think that's right. So you get back to one of the conversations the industry really had with the SEC was information asymmetry. So if somebody is dealing or trading in a token, there's information asymmetry, so we need to solve for that. Well, a token is not a traditional security. A token doesn't give you a right title or interest in an issuer for the most part. AICOs are a little bit different. So that's like saying we have information asymmetries in gold. Who's going to make all of the disclosures for the gold trade? So really, if there are information asymmetries, when I hear that, is code for protecting the consumers and make sure the consumers have as much information that they need if they're going to be trading in this. So to the extent it is a traditional security, you can solve it through traditional information disclosure. To the extent that it is a commodity, the CFTC can then deal with it in different ways. To the extent that it's a virtual currency, guess what? You have fraud tools, wire fraud tools, and other tools to combat bad actors through the Department of Justice and other enforcement agencies. Deal with it there. So it's really it's not the land grab, it's managing the risks that are well known, but managing them in a way that is smart and practical and doesn't smother the technology.
think that's definitely key. That doesn't smother the technology. I think we have a fantastic opportunity ahead of us. We have a door open now where it was wholeheartedly closed before. And we have a lot that we've learned as lessons learned so that we never repeat those lessons, hopefully again. And we can move forward with a very innovation forward approach in this space. So thank you to both of you for the conversation. And I hope everyone here has found it very instructive.